Thank you. Mr. Sims, can you remove your hat? We're going to begin soon.
And what?
Can you remove your hat? We're going to begin soon. Recording session on page 1. Kendallin Toll versus Eric Sims.
For the record, this matter is before the court for reviewing medical documentation submitted by defendant father Eric Sims to facilitate his request to reinstate parenting time or modify parenting time. This hearing is being conducted via Zoom. Our president is Attorney Maria Zagorski, representing plaintiff mother Kendallin Toll. Is Ms. Toll present on audio?
Yes, she is, Your Honor. She's not going to turn on her video because she's somewhere else at an appointment that ran late, but she's here.
That's fine. Thank you. And good morning, Mr. Sims.
Good morning, Your Honor.
Mr. Sims did provide the court with a number of documents. I don't know whether that was provided to Mr. President in front of the court and Mr. Zagorski.
It was, Your Honor. Yes, we both received it. Yes.
Letter from his probation officer, Ryan Rupp. And they all seem to be positive that Mr. Sims is doing what has been recommended in terms of counseling and complying with the terms of his probation. So, of course, received a fine recommendation after the parties conferred with Mr. Pratt this morning that father shall have a therapeutic parenting time at Family Counseling Shelter Services or a comparable therapist. Any out-of-pocket expenses shall be paid by defendant father. So this is a means by which to move forward, Mr. Sims. And after a period of time, went through some positive reports from Family Counseling Shelter Services, we can perhaps consider and look at some normal parenting time. Obviously, it's important that we need to reestablish contact with you and your son. Ms. Zagorski, is this recommendation agreeable with your client this morning?
It is, Your Honor.
All right. Mr. Sims, do you understand the recommendation this morning?
Yeah, I do, but I don't necessarily agree with it.
Well, obviously, when's the last time you had physical contact with your son? It's been a year?
September 2022.
Over a year. Obviously, it's he's a child, and obviously we don't want to thrust him into the situation where he's going to see this his father, who he's not seen in a year and a half. The recommendation seems to be reasonable and appropriate that we sort of start with small steps with the idea that we in a very careful, measured fashion try to reestablish a relationship between father and son. We don't want to go backwards. So we don't want to force things on your son where where he's just going to totally shut down. This appears to be the best means by which to move forward. Ms. LaPrade, what's the waiting list right now? Obviously, both parties need to make an intake, schedule an intake.
So, Your Honor, the last time I spoke with family counseling, and I did discuss this in the breakout room with the parties, which is why the alternative is in there that they can use a comparable therapist. The last time I spoke with them, it was 2 months, which is why it makes sense to allow a private therapist to be involved. And Ms. Zagorski stated that the child does have health insurance. So,
okay. Ms. Zagorski, does your client have in mind? Mr. Sims, did we lose you?
No, I'm just looking at the hours of that facility.
Okay, all right. We just want to make sure. Mrs. Zagorski, is your client able to identify a therapist? Has the child been in counseling at all?
He was in counseling. I don't know that his current therapist would be willing to do this. If she would, then that's fine. Caleb is resistant to returning to therapy. But if Mr. Sims wants to find somebody who can provide this service and provide reports to the court, I think that's the biggest hiccup, is that most private therapists don't want to do reports and don't want to have to have their case notes not public, but available to the parties. But we're open to it if Mr. Sims finds somebody.
Okay, but so your client does not have any suggestions, correct?
No.
So Mr. Sims will have to look. Okay.
Not offhand.
All right. Well, in the meantime, the court would order that both parties contact Family Counseling Services and schedule an intake and get on that waiting list. Mr. President, possibly we can put their phone number on this order.
absolutely, Your
For
Honor.
that agency, make it really easy for the parties. So, Mr. Sims, what the court suggests is contact them, Child Services, conduct an intake. I believe that can be done verbally over the phone. Each of you will pay your own intake. And get on that waiting list. And in the meantime, if it might take they could tell you better whether or not it's active, if it's a 2-month waiting list. Get on that waiting list. That is key. So I would suggest just call that agency this week, conduct the intake, and get on that waiting list. In the meantime, if you can find a therapist that is willing to meet with you and Caleb, and then provide reports to the court, maybe meet once a month initially, or twice a month. If that person is willing to be present when the two of you meet each other, then obviously reach out to Ms. Toll and let her know I've identified a therapist that's willing to do this, and then she contact therapists and they can schedule a time for her to bring Caleb to that therapist, where you'd meet Caleb in the office of that therapist.
I can't reach out to Miss Toll. I have no contact with Miss Toll in my felony probation order.
Okay, you can reach out to Mr. Gorski then.
Yes. Yep. Feel
Reach
free to
out
call
to-
me, Mr. Sims. Call or stop by.
So find out from your insurance in terms of a family therapist that you're covered by your insurance, and at least check that out, because maybe you can get in much quicker. But in the meantime, make that intake with them, Child Services, get on that waiting list as soon as possible. The court would like to, rather than just leave this open-ended, the court would like to set a review date in a couple months. The court sincerely wants Mr. Sims. Mr. Sims seems to be very committed to a risk relationship with his son. The court wants to help facilitate that. Mr. Sims, so we're not just going to put this matter in limbo. We're going to schedule a hearing date.
Your Honor, I have a question.
Okay, we're going to schedule a hearing in late April, early May. What's your question, Mr. Sims?
In the meantime, being there's potentially going to be a 2 to 3 month wait, I was wondering if you could order that I'd be able to FaceTime my child.
Right. Did you discuss that with Ms. Zagorski and Ms. Toll this morning?
No, I did not.
All right. Well, that's the time to do that. Ms. Zagorski,
Your
any
Honor,
objection to FaceTime?
I do, unfortunately. I'm.
How about Ms. Toll? Does Ms. Toll have an objection? Maybe I'm going to put you back in the room with Ms. LaPrade. So there'll be some discussion. I'd like to hear Ms. Toll's opinion on it. Ms. Zagorski, I appreciate your thoughts, but it really should be between the parents. I'm going to put you in the break room with Ms. LaPrade, see if there's any possibility of FaceTime in the interim.
Yeah,
Go back to join breakout room.
mine doesn't say that. It only says leave meeting.
There should be a button elsewhere, not the leave button, but a different button that says join breakout room.
I'll put them in 3 because just.
All right, but the court's backing up this morning. Let's just do this here on the record. Bring it back, Sarah. I just we're going to back up here. Ms. Gorski, we have review dates of April 30th or May 1st. We got April 8:30 either day.
Either day is fine with me.
Any preference, whether Tuesday or Wednesday?
No, we can do Tuesday the 30th.
Okay. Okay, Mr. Brett, I'm gonna get backed up this morning, so I'm just gonna do this on the record. But we'll set a review date of April 30th at 8:30. We have Ms. Toll here, but Mr. Sims we appear to have lost, and I apologize.
He's here, Your Honor.
All right, Mr. Sims, can you hear the court? Mr. Sims, you need to unmute yourself. All right, Ms. Toll, Mr. Sims, the father of your child has asked that he be permitted to FaceTime with Caleb. Do you have any objection to that?
I do. I think it's best that they speak with a counselor together first.
Because there's been no contact.
I'm sorry, what was that?
Because there's been no contact for such a long period of time?
Yes, I'm afraid. I mean, I have no idea how that would go, and I just would rather it be in a safe place to begin with.
Well, obviously it'd be safe because the kid would be in your home.
Right, but there would be no record of what he says to him or what he talks about, and he has a history of not saying the best things to him.
Okay. Has Caleb inquired about his dad?
No.
Okay.
Your Honor, I don't
All
think he
right,
wants to see him, and that's why we wanted this, the therapeutic, is that the relationship is very much broken and it does require a professional's intervention. I mean, if we're sincere about repairing it, we need some help because Caleb is not interested in a relationship with his father at this point. There's been a lot of damage.
All right. So Mr. Sims, Ms. Toles is opposed to any FaceTime right now until we have some professional intervention, like a therapist, and the court does not disagree with that. So at this point in time, the court will not order any FaceTime, but the court will schedule us for review here on April 30th at 8:30 a.m. So I'm gonna keep this on the court's docket till we have till we make progress toward restoring that relationship with your son. So the court would urge you to continue doing what's expected of you right now. Continue to do that, Mr. Sims, and don't give up hope. So again, contact this agency, Family Court Child Services, schedule the intake. Ms. Toll, you do likewise, so they at least get you both on the waiting list.
Okay. Thank you, Judge.
And Mr. Pratt's going to provide the phone number in this order, and we'll review this matter as per any time, April 30th at 8:30 a.m.
Thank you.
Okay, any other questions, Mr. Sims?
Nope. Thank you, Your Honor.
All right, don't give up hope.
No,
All right,
I
that
don't.
concludes my, thank you, Ms. Skorsky. Thank you, Ms. Pratt. You can, that concludes my, you can all zoom out.
Thank you.
For the record, this matter is before the court for purpose of reviewing defendant father's parenting time. This hearing is being conducted via Zoom. Present is Attorney Maria Zagorski, representing the plaintiff mother, Kendall and Toll. Ms. Toll is present. Good morning, Ms. Zagorski.
Good morning, Your Honor.
In addition, defendant dad, Eric Sims, is present. Good morning, Mr. Sims.
Good morning.
Okay, the parties have conferred with Ms. LaPrade, I believe, in front of the court this morning. Ms. LaPrade has provided the court with fine recommendation, noting that the therapeutic visits with family counseling child services have not yet begun. The court's disappointed. I was hoping that we'd have some track record with respect to that. Ms. LaPrade, do we know where Mr. Sims is on the waiting list? Do we have any idea, time frame?
Mr. Sims spoke with them yesterday and was directed he is the next one on the list.
Okay. So the recommendation this morning, Mr. Sims, is that we come back to court to review your parenting time on July 16th at 8:30. Are you still on probation, Mr. Sims?
Say that again.
Are you still on probation?
Yeah, I'm likely going to get an early discharge, but I just got switched from once a month reports to every other month. And
Good.
I believe I'm going to get off on August 2nd.
So it sounds like you are in full compliance. That was the question the court had, is if you're in compliance with your probation, no violations. That's a positive thing. Ms. Skorsky, has Mr. Sims had any contact with his son? Is there, I can never recall if there's any video chats, or nothing's been permitted at this point. Is that correct?
That's correct.
All right. Right, to Mr. Sims, do you understand the recommendation?
Yeah, so the reason I asked to go in front of you this morning is because of what you just mentioned, that my family and myself want to be able to call or FaceTime my son. Is coming up on 2 years since any of us seniors spoke with him.
Did you discuss that this morning with?
Yeah, I did. They
Ms.
were.
Toll and Ms. LaPrade?
Yeah, I did. They weren't optimistic to that.
Okay. Obviously, there's always concern in terms of without a therapist being present to make sure that the reception is positive for your son, having no contact in almost 2 years. Ms. Zagorski, is your client opposed to any video contacts at this time, or even maybe just after an hour at a park, supervised parenting time at a park or something?
No, Your Honor, we do have a problem with that. The whole point of the therapeutic, this isn't supervised parenting time. This is therapeutic parenting time. And the purpose was to reintroduce Mr. Sims into the child's life. Because as you indicated, it has been almost 2 years. Mr. Sims I've set forth his history. You're aware of it. And we want it to be positive and we want it to be healthy. My client did reach out to another therapist, a private therapist, and she has kept in touch with Family Counseling and Shelter Services. And she does want to facilitate this, but she wants it to be a good experience for Caleb.
Well, that's all this court wants. That's the court's primary concern, Mr. Sims, is your son. And yes, obviously, I'm sure you likewise want this to be a healthy reintroduction, positive, constructive. So the court could just hoping that that you will have had a number of sessions between now and July 16th. I understand your concern, and we will revisit all this on July 16th at 8:30. So be patient, Mr. Sims. You're moving in the right direction. Hopefully, maybe you'll be off probation by then. Anything further this morning, Ms. Zagorski?
No, thank you, Your Honor.
Mr. Sims, anything further? The court fully hears you. I understand your concern and your desire to be reunited with your son. We've got to do this in a careful, deliberate fashion for the best interest of your son.
The only other question I have is I noticed on the last court order it said that father is to pay any out-of-pocket expenses. I would like that to be split between us.
First of all, do you know what the out-of-pocket expenses are for family
Yeah, it's
counseling shelter services?
It's $50 per session.
Okay. Well, I mean, you can always ask that, but again, aren't we in this position because of conduct on your part? We wouldn't be even talking about this issue if it weren't for the incident that that occurred back in September of 2022. Is there anything that mother did that has brought us to where we are today? So I think it's appropriate that any out-of-pocket expenses be paid by you. So again, the court will adopt then Ms. Pratt's recommendation this morning. Any prior orders and consistent with this order will continue. So we can revisit all these issues again. Are you employed, Mr. Sims?
Yep.
All right. Okay. I mean, if you couldn't afford it, we want to make this happen when maybe perhaps a circuit court fund could pay some of this. But if you're employed and you're able to pay it, then you should be paying it. If you are laid off or injured, then perhaps the court can pay that.
No, the only reason I brought it up is because I'm not the one requesting that this be done.
Well, as I stated, we wouldn't be here in this position if it weren't for your conduct back in September of 2022. So with that, the court will adopt the recommendation. We'll see you back on July 16th at 8:30, and hopefully you'll have contact with your son in a deliberate atmosphere and setting between now and then. All right, that will conclude this matter. Everyone can zoom out. Have a good rest of the day. Thank you, Mr. Brad.
Your Honor.
Thank you, Your Honor.
Welcome. Father's motion to modify and increase parenting time. This hearing is being conducted via Zoom. President Attorney Christina Hills, representing the plaintiff, Mark Johnson. Mr. Johnson is present. In addition, Attorney Eric Chappell is present, representing defendant Mother Heather Kane, and Ms. Kane is present. Good morning, everyone.
Good morning, Your Honor.
Parties have conferred this morning with Ms. Patrick in front of the court, is recommending that the court deny the plaintiff's motion to increase parenting time. Ms. Hills.
Your Honor, my client is obviously not in agreement with that recommendation. We are here in front of the court asking for an additional approximately 18 overnights during the school year. My client believes that that would offer additional stability for the children, as well as satisfy their requests to him, which have been made spontaneously regarding having equal parenting time with both parents. It's been about 9.5 months since the entry of the judgment of divorce and the current parenting schedule. That's enough time to get through a full summer of the children off school, as well as 2/3 of a school year at this point. The children have become confused as to whose week it is, as to whether they have 2 overnights or 1 overnight with dad. There have been issues with do they ride the bus? Do they not ride the bus? And having them know a set schedule each week with mom and dad, mom having Monday, Tuesday, dad having Wednesday, Thursday. would help with that, provide some stability. There have been issues with the children forgetting things, going back and forth, depending on which week it is. The children mistakenly believing that they were not able to do activities on Dad's week because of the mom, dad, mom schedule in the middle of the week, meaning the Tuesday, the Wednesday, the Thursday. He has a new place since the entry of the judgment of divorce. It is a lot more comfortable for the children. That has become a bit temporary, though, because he's intending to move into a much bigger home, what will be his and his wife's forever home, hopefully. They've closed on that and will be hopefully moving in sometime around April of, I'm sorry, they have a signed purchase agreement and will be closing on that in April, providing even more room and comfort for the children while at his home. He has been equally involved in all of Gus's issues related to his diabetes diagnosis, which happened during the course of negotiations in this case for purposes of the final judgment. That was raised as an issue by mother in support of her opposition to our motion. That really is a red herring because Dad has gone to all of those appointments for Gus. He is the one who took Gus to the emergency room in the first place, noticing that he was having significant issues. He has been to all of the same training that Mom has with regard to Gus's diabetes diagnosis. And if Dad had been having problems, you can certainly bet that Mr. Chappell would have filed a motion on his client's behalf to modify the parenting time prior to now. There's been no such motion, no such complaints that I've been made aware of as to anything that Dad is doing or not doing with regard to Gus's diagnosis. There was an issue raised about another stepchild in my client's home who allegedly has emotional issues. Mom has never met that stepchild to my knowledge. She has no basis for making any such allegations, and my client very much denies that there are any issues between the siblings. And in fact, they have a very good relationship. It's not without bumps. They are still children. But it's very good overall, and the kids have really become fast friends. So for all of those reasons, primarily the stability of the children, getting rid of this back and forth between Mom and Dad, and the confusion that the kids have with regard to riding the bus and activities and that sort of thing. And in particular, their request for equal parenting time. My client is asking that his motion be granted, that he be given that Thursday overnight in the off week so that he has a standard 2-2-5 schedule with Mom having Monday, Tuesday overnight, Dad having Wednesday, Thursday overnight during the school year. The summer we're asking stay the same, which is the week on, week off schedule.
Thank you, Ms. Sills. And the court does recognize that the parties have equal parenting time during summer months, week on, week off. It's appropriate. In terms of modifying parenting time, I understand it's a lower threshold than that of modifying custody. I don't know, the court has a hard time finding any change of circumstance or any cause. Okay, Dad moved into a bigger home. Well, I think it's more for the benefit of Dad. He's remarried, he's got stepchildren now. Is that really a change for the children? Court questions that. And I agree, it's a lot of back and forth for the kids. Maybe what we do is we eliminate the midweek parenting time. With that, Mr. Chappell?
Your Honor, we obviously agree with the recommendation. We don't think that there's been a sufficient change of circumstances. I'll note for the record, Your Honor, that before these parties were ultimately divorced, when you signed the judgment of divorce on May 10th, just last year, the parties were living separate and apart and had lived separate and apart with a similar schedule. And when they got divorced, each of us came into court and said that the current schedule was in the best interest of the children as they were operating under that schedule. Nothing has changed. A new house doesn't change it. We deny that there's any instability. We deny that that there's a great relationship between the step siblings. There are some issues, but this is what the parties have been working under. Really for just a short period of time. So without having to get into the arguments as to whether it changes the established custodial environment, we think that even under that lower threshold that there has not been a sufficient change of circumstances.
And the court certainly understands it's a lot of back and forth for these children. I mean, the two parents are in the best position to decide what's best. Right now, the current parenting time schedule, 1 week Dad has the kids on Wednesday, the next week it's Thursday overnight. Is that correct?
Wednesday and Thursday, Your Honor.
Wednesday, Thursday, 1 week, only Wednesday, the
His off weekends, he gets those 2 days.
which is where the children get confused as to whose week it is, which bus they ride, those sorts of things. Judge,
Naturally, I mean, and I think the parents should discuss that. It's a lot for those children. Very confusing. And if in fact there's a motion to modify this, the court would look seriously at that. I mean, it's too much back and forth for these children. But at this point in time, the court, Ms. Hills, is inclined to adopt this recommendation. But I know you had another thought you wanted to share.
Your Honor, we are open to mediation and sitting down and trying to talk through these things. We have a hearing set on April 30th on a child support issue. We would be happy to adjourn this out to that date, have the court consider it after mediation. I also think that this has been a relatively high conflict case. Parties are having some issues with co-parenting, even to the point of one mom not letting one of the children go to a birthday party for the other child while in dad's care. I think they both could benefit from the high conflict solutions workshop. So potentially with that, together with a mediation, maybe we can make some progress. And if not, then the court can make whatever decision it feels is appropriate on April 30th.
Mr. Chappell?
Yeah, Your Honor, we're just looking to conclude this motion. We've already had another motion, obviously, that they've continued to another date. So when it doesn't happen the way that Mr. Johnson wants things to happen, he just tries to extend them rather than just conclude them. We don't want to have another open matter. And relative to the communication, the parties have app close. They're able to there has been communication. We don't think that going to a workshop is going to change what happens between these parties.
And Your Honor, that is a very unfair characterization of this child support issue. We adjourned that after mom directly involved the just turned 18 minor child in the discussions and the negotiations regarding that matter. We took it off so that that child would not still be directly involved in that case. But in the chance that the child moved back with my client, we still wanted the opportunity to address that issue with the court. So this is not my client simply wanting to put things off. This is him trying to do the right thing by his children in both cases.
All right, thank you. Court at this point in time doesn't necessarily believe that the agreement reached by the parties relative to parenting time is in the best interest of the children, but that's what they agreed to. At this point in time, the court will deny the plaintiff file's motion to increase or modify parenting time. The court will, in addition, and I agree with the Ms. suggestion, we have some high conflict here. We need to reduce this for the benefit of the children. We're not even a year out from the divorce. The court will order that the parties complete. It's an online class, a high conflict solutions workshop. Ms. Patrick, you can add that to your recommendation that the parties shall complete. I think it's highconflictsolutions.com. Perhaps you got that. If not, you can call up here and I can provide you with the exact address. The court will order that the parties complete that program. Hopefully that will assist them in agreeing between themselves what's best for the children. It is a lot of back and forth for these children. It's confusing. But at this point in time, the court's not going to increase parenting time.
Thank you, Your Honor.
So with that, without collision error, can zoom out. We're just going to add that one provision to this recommendation. Without collision error, can zoom out. Have a good rest of the day.
Thank you.
Thank you, Ms. Hills, Mr. Chappell.
Corrected into your queue, Your Honor.
Thank you. And if there was a motion here to reduce it, I'd get rid of some of those overnights. It's way too back and forth for those kids.
I made a proposal, Your Honor. He did want to take it. Mom was willing to take the proposal that would have stopped that back and forth. He was not willing to take it. There you go, Your Honor. I'll get rid of the other one.
Thank you.
I'm trying to.
Court is now in session, top of page 1, William McLaughlin versus Misty McLaughlin.
For the record, this matter is before the court for the purpose of reviewing parenting time. In addition, a couple additional items added to the court's docket. The name of the plaintiff's motion for to show cause, alleging a violation on the part of mother on priorities of this court regarding transportation of minor child to facilitate parenting time with dad, as well as the plaintiff's motion to modify judgment divorce relative to tax exemptions and to review child support. In addition, the defendant's motion for to show cause regarding alleging plaintiff's failure to comply with the terms of a judgment relative to the sharing of extracurricular activity expenses for the children. The hearing is being conducted via Zoom. Present is Attorney Catherine Kajewski and Kevin Kajewski representing the plaintiff, William McLaughlin. Mr. McLaughlin, are you present on audio?
Yes.
Okay, good morning. In addition, Attorney Kimberly Kuhn is present representing the defendant, Misty McLaughlin, and Mrs. McLaughlin appears to be present with Ms. Kuhn. Good morning.
Good morning, Your Honor.
The parties have conferred at length with Mr. Walker this morning, who has provided the court with a fine recommendation. Individual counseling shall continue once a month at the counselor's discretion. Plaintiff shall provide a list of family counselors that are covered by his insurance within 24 hours. The attorney shall exchange a list of no more than 3 counselors each. From the 2 lists, the attorney shall choose 1 counselor on or before Friday, March 8th, 2024. Family counseling with the father and children shall commence as soon as possible. The defendant mother shall not be in with the children's counseling session program unless the counselor requests that she be present. The issue of child support should be referred to the front of the court for a formal investigation recommendation, with each party having 21 days in which to object to any recommendation. Further, that the frequency of any family counseling shelter shall be once every 2 weeks unless the counselor deems otherwise. Father shall pay any out-of-pocket expenses for family counseling shelter, any family counseling sessions. The motion to modify tax exemption be denied at this time. All communication between the parents shall be via app close. The party who signs up the minor child and children for non-school related extracurricular activities shall provide the schedule to their parent on app close. If the child is not going to attend an extracurricular activity, the parent who shall have taken them shall inform the other party that the minor child will not be attending. Any modification of support shall be effective February 1, 2024. The plaintiff and defendant's motion to show cause to be reserved. The parties will appear back before his court to review all his issues on May 21st, 2024 at 9:30 a.m. I don't know if that settles or resolves any issues, but that's the recommendation of Mr. Walker.
And if I may, to begin, Your Honor, I believe that is a summation of all the issues and the resolution to everything that has been put forward by plaintiff and also defendant, but certainly I defer to sister counsel.
I agree, Your Honor. We are in agreement. I believe it's my understanding that all counsel and both parties are in agreement with that recommendation.
That's correct.
Okay, wonderful. So between now and May 21st, we'll work on getting the quadro entered, and we'll address the issue of the soccer expenses and the issues regarding the motor vehicles, the Ford Fusion and the Ford Focus. All those issues will be addressed between counsel and the parties in the interim.
Yes, Your Honor. My motion, opposing counsel just received that motion on Friday. So we've reserved the issues, and I will be discussing those issues, and we're going to work towards a resolution of all of our outstanding issues. I know that with regard to the counselors, right when we're done with this hearing, I'm going to be contacting Catherine. We're going to expand the counselor search. I don't know what search engine or what search criteria was used, but there's only 8 counselors, I guess, on a list. So obviously I want to expand the counselor selection. I don't know if my client's home address was used or Mr. McLaughlin's home address was used. The parties are divorced. They're in separate residences. So I want to see what we can find in terms of getting a bigger family counselor pool so that we can find a good and appropriate counselor for the family counseling. So we're working on those issues, and I have no indication that counsel and I aren't going to be able to work on all of the other issues too, Your Honor. I'm very optimistic.
We are as well, Your Honor.
I'm pleased to hear that. We have some good defense law practitioners on board, and hopefully they can help these parties address these issues. It's important that obviously dad develop a relationship with these teenagers. They're going to be adults before we know it. And obviously, if we can find the right counselor, the court, that counselor can make a difference. Right, Mr. and Mrs. Majewski, or counselors, you wish to barge your respective clients regarding this recommendation this morning?
Sure. When it comes to Mr. McLaughlin, can you first hear me? I know you're on video, on audio by phone, but can you hear me?
Yes.
Okay. I only have a handful of questions. So, sir, did you hear the recommendation from the FOC referee that the judge was able to read on the record?
Yes.
Are you in agreement with everything that he stated regarding how we're going to be handling the issues that have been presented in the various motions brought by the parties?
Yes.
Do you have any concerns or any apprehensions or anything like that? Any additional questions for myself or the court, or are you okay right now?
I'm okay right now.
Okay, thank you very much. Anything from the court you'd like to ask on my client, Your Honor?
No, thank you, sir.
Thank you.
Ms. Kuhn, do you have any questions for Ms. McLaughlin?
I don't, Your Honor. She understands rec.
All right, again, the court would like to thank Mr. Walker for his time this morning, but particularly the optimism of counsel for the parties. Hopefully that can be shared with the parties, and we'll make some progress between now and our review on May 21st. We'll put this back in the court's docket May 21st at 9:30. That will conclude this. Everyone can zoom out. Have a good rest of the day.
Thank you. You too, Your Honor.
Josh, thank you for your help on that first thing this morning.
You're welcome, Your Honor. That was a fun
very
one.
Involved. Very
That was
involved.
fun.
So
Yeah.
I appreciate spending time with them, and obviously they seem to be optimistic they can move their clients in a direction. I know just so many issues right now, so hopefully they can narrow down and eliminate a lot of these issues before we come back in May. So thank you for your time and efforts in that matter.
You're welcome. I think that really the key is always communication, but I think especially on that one, the parties are having a very hard time communicating with each other. If they can figure that out, I think they'll be able to figure everything else out.
We have so many less problems in this world if people just communicate.
Yeah.
Listen. Thank you.
You're welcome. Thank you.
Exam session, page 2, Ken Lush versus Catherine Avery Dugo.
Record this matter is before the court and the defendant mother's motion to reinstate parenting time. This hearing is being conducted via Zoom. Present is Attorney Mark Cobb representing the late petitioner, Catherine Avery Dugo. Is Miss Avery Dugo present on audio? Okay. She's not connected yet. Also, Mr. Ken Lush is present. Mr. Lush, you're muted.
Sorry, Your Honor. Yes, I'm here.
Okay, now I can hear you. On this matter, Mr. Cobb, the court's office did receive a communication from plaintiff, Mr. Lush's attorney, Anthony Bruskel, who advised he had some medical procedure today and could not attend. So he wanted to give the court a heads up on that, but indicated that you were opposed to any adjournment of this matter. Oh, now we have Miss Avery Dugo. Can you hear the court, Miss Avery Dugo? Technical problems with her device. So, Mr. Cobb, did Mr. Bruskel reach out to you as well?
Yes, Your Honor. He did speak with me about his unavailability, and I did speak with my client about it. And first, I just want to make clear, I bend over backwards to extend the same professional courtesy to attorneys that I would like extended to me. It's just in this case, we're talking about parenting time. And right now, it's not that my client is getting, a small amount of time and she's petitioning for more. She's getting none right now. And so she really doesn't want further delay. She really is anxious to start parenting time with her daughter. So that just due to the nature of this motion, she's not getting any time at all. She really would like to spend some time with her daughter.
And the court fully understands that. Again, her parenting time was suspended on August 16th, 2023. I mean, why she didn't petition the court before then? She's waited now, 6 months to petition the court. The court does not believe a week's going to make any difference. So, Mr. Patrick has recommended the court adjourn this matter to March 5th at 3 o'clock so that Mr. Lush's attorney can be present. Are you available on that time, Mr. Cobb, March 5th at 3 o'clock?
I am, Your Honor, and at the risk of drawing the court's ire, I just wanted to say one more thing as far as it being suspended in August. She did contact our office. I don't remember the exact date, but there were some things we had to do kind of behind the scenes in preparation for this. And so she did contact us, and she is definitely quite anxious to begin her parenting time.
And that's understood. Has she had any contact with this child in the past 6 months? Do we know?
I don't believe she has, Your Honor, because of the
Right.
order of suspension.
All right. She's still not connected. Yeah, she's still not connected, but in any event, hopefully maybe she can suggest, we'll give you a phone number. She can call in, and that if she has poor internet or a bad device, Mr. Cobb, you can jot down this phone number, you can pass it on to her. But the court will in fact adjourn this matter to March 5th at 3:00.
Correct.
And after she shares that phone number, it'll prompt her to enter the Zoom ID number. So then she can hear very clearly on audio. It really makes a difference. She doesn't need her computer.
Okay, let me try to call her real quick.
So, no, the court's adjourned the matter to March 5th at 3:00. That's what the court's going to do. So you can just let her know I'm backing up here on my docket. The court will enter an order today, copy mailed to you March 5th at 3:00. I understand she's anxious for parenting time, but we're going to give Mr. Lush opportunity to have his attorney present. So just a 1 week adjournment.
Okay, Your Honor.
Thank you,
I'll let her know. All right, thank you, Your Honor.
Thank you. Have a good rest of the day. All right, Mr. Lush.
Okay, thank you.
Keep contact with Mr. Brusco. Put it on your calendar, March 5th at 3:00.
Thank you, Your Honor.
Welcome, and let Mr. Brusco's office know March 5th at 3:00.
I will do that.
Thank you, Your Honor.
Okay. All right, I will conclude this matter.
Thank you.
You're welcome. Have a good rest of the day. For the record, this matter is before the court for the purpose of reviewing DNA test results. This hearing is being conducted via Zoom. Present is Attorney Leslie Carr, representing the plaintiff, Devin DeBerry. Mr. DeBerry appears to be present. Is Autumn McLeod present on audio?
Yeah, I can't get my camera to come back up. There it goes.
Fine, at least as long as we can communicate. It appears that the court is in receipt of a DNA test report dated February 19th, 2024, which confirms and indicates a significant probability of paternity on the part of Mr. DeBerry. 99.999996% probability of paternity. Ms. McLeod, did you receive a copy of that?
Yeah, I can't get my camera to come back up. There it goes.
Fine, at least as long as we can communicate. It appears that the court is in receipt of a DNA test report dated February 19th, 2024, which confirms and indicates a significant probability of paternity on the part of Mr. DeBerry. 99.999996% probability of paternity. Ms. McLeod, did you receive a copy of that DNA test result? Okay.
Yes, I did.
Attorney Mark Gilbert is no longer representing you. Is that correct?
Yes, he is. He was in another hearing. He just contacted me.
Okay. So are you willing to proceed then without him being present?
Yes, I can. He's trying to call me at this second.
Would you agree that court can, do you have any objections to DNA test report?
I'm waiting for him to come in. He said he was coming to the.
Okay, the court can't wait for him. This matter was scheduled at 10:30.
Yeah, we can proceed.
Okay, do you have any objection to this DNA test report?
No.
Are you contesting
No
paternity on the part of Mr. DeBerry, that he's the biological father of your child Isabella?
He is the father. Yes, I acknowledge.
All right, Ms. Card, likewise, is your client asking the court to adopt this DNA test result and determine that he is a biological father of the minor child?
Yes.
All right, Mr. DeBerry, Ms. McLeod, can you both please raise your right hand to be sworn? Do you both solemnly swear affirm that the testimony about given this matter will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
All right, thank you. Ms. Carr, we're going to begin with Mr. DeBerry, just to listen to some brief testimony regarding paternity.
Yes, thank you. Mr. DeBerry, could you please state your name for the record?
Devin DeBerry.
And Mr. DeBerry, were you at one point in time in a relationship with Miss Autumn McLeod?
Not necessarily.
Did you have sexual relations with Miss Autumn McLeod?
Yes.
Okay. And did you have that approximately 9 months prior to January 28th, 2021, when Isen was born?
Yes.
And had you, at the time of her birth and moving forward, believed that you were the biological father of Isabella?
Yes.
And were you told at any point in time, before or after her birth, that you were her biological father?
Yes, I was told at one point that she believed that I was the father.
And what was the time frame in relation to her birth that you were told that?
A few months after she was born.
Okay. And you understand at the time of her birth, someone else signed that affidavit of parentage saying that you were Isabella, or that he was Isabella's father, correct?
Yes.
And that was Mr. Jorgensen.
Yes.
But you believed that entire time that you were the father, and you had in fact taken a like a home DNA test at some point in time. Is that correct?
Yeah. Well, I believe I didn't know when she was born, but you know, Autumn assured me that, you know, that was his child, until she started to believe maybe it wasn't, and we should do a DNA test, and we did, and
that showed you were the father.
Yeah.
And then you did this DNA test more recently at a lab, and that confirmed that you were the father of Isabella.
Yeah.
And you have no doubt in your mind that you are the father of it.
Not at all.
Okay. Thank you, Your Honor. I have nothing further.
All right. Miss Autumn McLeod, can you please state your name for the record?
My name is Autumn McLeod.
Ms. McLeod, you heard the testimony of Devin DeBerry this morning. Is that correct?
Yes.
Was his testimony true and accurate to the best of your knowledge?
Yes.
All right. Attorney Mark Gilbert has now appeared. Good morning, Mr. Gilbert.
Good morning, Your Honor.
The card simply acknowledged receipt of the DNA test report. And Ms. McLeod indicated she had no objection to adopting that, this court adopting and accepting that DNA test report, which shows a significant probability of paternity on the part of the plaintiff, Devin DeBerry, the alleged father. And the court was just beginning some inquiry of her regarding paternity. Did you want the court to complete that, or did you want to take over?
Please, you already began, Your Honor. I heard the beginning. Go ahead.
All right. So I'm sorry, Ms. McLeod, once again, you're the testimony of Devin DeBerry this morning, correct?
Yes.
Was his testimony true and accurate to the best of your knowledge?
Yes.
Do you, excuse me, do you admit and acknowledge that Devin DeBerry is in fact the biological father of your daughter Isabella, and
Yes.
not one Ronald Jorgensen?
Yes.
Any question in your mind?
No.
All right. Do you have any questions for the court?
No.
So, Ms. Carr, did you have any questions for Ms. McLeod?
No, I do not. Thank you.
All right. The court's received a fine recommendation from Mr. Walker this morning. And Mr. Walker is recommending that the court enter the following order: that the court determine that Ronald Jorgensen is not the biological father, that the affidavit of parentage be revoked, and that the plaintiff, Devin DeBerry, be deemed the biological and legal father of Isabella. Mr. Walker is also recommending that the parties shall share joint legal with physical custody to the defendant mother of his 3-year-old child. Fathers shall have parenting time every Tuesday and Thursday. The paternal grandmother shall be present for the first half hour of every visitation. Father's parenting time should be unsupervised after the first half hour of every session. Commencing April 1st, 2024, father's parenting time shall be unsupervised and reasonable and liberal as parties can agree. Finally, the parties will appear back before this court to review parenting time on June 4th, 2024 at 10:30 a.m. via Zoom. That is the recommendation. After Mr. Walker discussed that with both parties. Ms. Carr, is your client agree with this recommendation?
Yes, he is.
All right, Mr. Gilbert, I don't know if you want to talk with Ms. McLeod. I don't know whether you want her to acknowledge. Ms. McLeod, you did participate in the discussion with Mr. DeBerry and
Yes,
Mr. Walker.
I did.
Okay.
Yes,
any
I did.
Any objection to this parent time recommendation?
Nope.
Okay, so that you and Mr. DeBerry can communicate, correct?
Yes. Yep.
Okay, so parenting time Tuesdays and Thursdays, will that start today or Thursday?
It would start Thursday.
All right.
It can start Thursday. I don't know if he has anything going on today.
Okay, so the two of you will communicate and set up a time on Thursday, correct?
Yes, we can.
Okay, and where will this occur? At your home, maternal grandmother's home?
His home.
Okay. So will the maternal grandmother transport the child over to his home?
Yes, until he gets his driver's license. I can, or my mother can.
All right. All right, so you have no objection to the court adopting this recommendation, and with the understanding that parties will come back in June to further discuss parenting time?
I have no objection.
All right. And Mr. Gilbert, do you have any questions for Ms. McLeod?
Nothing further, Your Honor.
All right. Anything further, Ms. Carr?
No, thank you.
All right. The court will adopt the recommendation. If you need a more specific order, Ms. Carr, you can prepare that. I don't know what the state of Michigan needs in order to revoke the affidavit of parentage. Maybe this is sufficient, but you can prepare a more formal order if you believe it's necessary. But the court this time will adopt the recommendation. We'll see everyone on June 4th at 10:30 to discuss review parenting time. Thank you, Mr. Walker. All right, that concludes hearing. You can zoom out after the rest of the day.
Thank you, Your Honor.
Thank you, Your Honor.
Welcome.
Thank you, Your Honor.
Thank you.
I'm sorry to keep you waiting.
The court is now in session, middle of page 3, Sonia Chavez versus Miguel Chavez.
For the record, this matter is before the court on the plaintiff's motion seeking modification of parenting time and/or custody. This hearing is being conducted via Zoom. Present is Attorney Jason Kazmarek, representing the plaintiff mother, Sonia Chavez. Ms. Chavez is present. In addition, the defendant father, Miguel Chavez, is present. This court did enter an ex parte order on February 15, 2024, suspending defendant father's parenting time based on an allegation revealed by the child that he was punched in the stomach by his father. Mr. Chavez has filed the response, and the court has reviewed and read that response. Mr. Chavez. Just one moment.
Yes, sir. Yes, Your Honor.
I'm going to share with you Mr. Walker's recommendation this afternoon. One moment, please. Mr. Kazmarek, did you receive the response filed by Mr. Chavez?
I did, yes.
Okay. Sometimes we don't get to the other party, and there was also, I believe, a couple of letters.
Yeah, Mr. Chavez dropped it off by office, so I did receive that.
All right, thank you. All right, after conferring with the parties, Mr. Walker has recommended that the ex parte order of February 15th shall continue. Father shall have video contact with the minor child every Saturday at 10 a.m., Sunday at 2 p.m., and Tuesday at 7 p.m. So Saturday at 10, Sunday at 2, Tuesday at 7. The parties shall return to this court on April 3rd, 2024 at 1:30 p.m. via Zoom, so that the court can be provided updates from protective services as well as the Taylor Police Department. That's recommendation. Obviously, Mr. Kazmarek, you're asking the court to adopt this recommendation. Is that correct?
Correct.
What about the school? The child will continue in the same school that the child had been attending?
Yes, same school.
Okay. All right. And Mr. Miguel Chavez, do you understand the recommendation?
Yes, I do, Your Honor.
And do you have any, are you opposed to the court adopting this?
Until I get the facts from the CPS worker, which she's already reached out to both of us, but until I have something written, I have to do what I have to do to show the facts and my innocence, and so that I can be with my son again. I don't like it, but I have to do what I have to do.
Well, the court would agree. It's sometimes protective services takes a long time to act, but the court cannot help. But note, this was a complaint made not to mom, but it was a complaint made to a school counselor. So obviously, your son was concerned enough or upset enough to relate to a third party outside the family, which is of concern. It carries a little more weight when it's just opposed to the complaints made to the other parent who wants to complain about the other parent. This was made to a third party.
Just so the court knows
Right.
that the child was interviewed on February 20th by a detective out of Taylor. Apparently, based on that conversation, there is an investigation being opened, and that's all we know, unfortunately. So I know the parties are both going to contact the detective to try to move it in this case, either close it out or do something with it.
The child was not taken to the hospital for an evaluation.
No.
Was he?
No.
Okay.
No, but he was seen by Megan Anger, CPS Child Protective Services. She saw there was no mark, and she also was told exactly what happened that morning to her. And I have on there her email and her cell phone. She had alerted me to let the court know to please contact her so that she can give the facts and what she had seen, and she saw no marks, and what was told to her on the day and morning of.
All right, thank you. Of course, the court doesn't reach out to parties. Usually if a party wants the court to hear someone's position, they produce that party for the court, and you have attached the safety plan. So in other words, Protective Services are they going to keep this case open until you complete a co-parenting class, or what's?
What she had told. No, she had come to me. She had she came over and she interviewed me, and what this was saying was that she was going to close the case because there was no contact, there was no punch, there was no marks, and so therefore there was no child abuse. And the way he describes me is as a loving father who's good to him, who's nice to him, who plays with him. No abuse seen in any other ways of all her questions would pertain to that. So she's going to close this case, and she has alerted me that she has contacted his mother as well and let her know the findings as also
not the same
myself.
message. It's not the same message to the plaintiff. So again, the investigation is still ongoing.
Well, that's the message I got from the CPS.
What did Miss Anger state to Miss Chavez?
Miss Anger called me on the afternoon of Thursday, I believe it was last Thursday, or the Thursday after the after the CPS report was made. She asked me if I needed to loop her in on anything and informed me that Miguel called her pretty upset, and I told her that I had filed a police report and that I had also filed the ex parte motion with my lawyer. She told me I was within my rights to do that and that CPS in front of the court were separate. And then she told me that she did not believe that there was an assault. And I asked her if she would be closing the case at this time, and she said, no, I have 30 days to complete my investigation and I'm not closing the case yet. So that was what.
And I heard from I heard from that same CPS worker on Friday and yesterday morning. I have text messages that prove that. We have been in contact, and she sees no, as far as her investigation sticks to what she has said. And I got a phone call from her Friday and a text message yesterday.
Right, Mr. Chavez, court suggests put something in writing that the investigation has been closed.
Yes, sir. Oh, yes. This is why I definitely have to wait for, yes, sir.
Okay. Mr. Chavez, who do you reside with?
I reside with my girlfriend.
Okay. And does she have any children in the house?
She has a child in the house, yes.
Okay. I'm trying to understand who lives in your house. A girlfriend, and how old is her child?
She's 13 years old.
All right. So does your son and your girlfriend's daughter have separate bedrooms?
Yes, they do. And the CPS worker seen this. She saw that we have separate bedrooms. Yes, sir.
All right. Again, at this point in time, Mr. Chavez, the court's going to adopt Mr. Walker's recommendation. We're going to err on the side of caution. CPS moves slowly, and it appears that they will, in fact, close their investigation. I don't know about Taylor Police Department. The court doesn't see any purpose served in prosecuting a father for an assault upon a child. But again, obviously, the one concern is that your son would make this complaint to a high school counselor as opposed to his mom. But we'll see what
No,
happens.
I know what
would hope that
happened,
we don't
Your
have father
Honor.
and son in court. So at this point in time, have Ms. Anger provide you with a letter. You can provide the court in advance of the April 3rd hearing that the CPS investigation has been closed. And hopefully we'll hear something from the Toledo Police Department, the Toledo Police Department in the interim as well. Have you been contacted by the agency yet, Mr. Chavez? Have they interviewed you at all?
No, they have not. And
Right.
I'm quite sure. I wonder, did Sonia provide them with my cell phone number?
I don't know.
I don't know. Well, I will be reaching out to them. I will be reaching out because I was told that the CPS worker, but I need to reach out because I need to get all these facts and everything in order.
Right. Well, Mr. Kazmarek has attached to his motion a copy of the officer's card, Officer Schnell, with a reference number. You can always contact Officer Schnell if you want to move the matter forward, get it off dead center, Mr. Chavez.
There's a different detective. That was the initial officer who took the initial report, but that was referred to a detective who forensic interviewed the child on February 20th. And his name, Mr. Chavez, is what?
No, I need to know because that's I was
sorry,
not.
Mr. Chavez, what's the detective's name?
The detective's name is DiGiacomo, Detective DiGiacomo.
Can you spell that?
Yes, it's spelled DIGIACOMO.
And a phone number?
All right, thank you. So maybe Mr. Chavez, you can follow up with Miss Anger and this detective, and hopefully we can put this matter to a conclusion so we can reinstate parenting time when we come back on April.
Yes, Your Honor.
So the FaceTime, just have just don't talk about this incident with your son, just to inquire how he's doing, how's school going. The conversation, don't accuse him of creating an issue.
No,
just have a good conversation with your son. So it'll start this Saturday, Sunday, and Tuesday.
Does it still reside that if he wants to call me, because I was told by his mom that he has asked for these phone calls that I've gotten in these weeks, that if he can still call if he wants to outside of that?
Does he have his own phone?
No.
Okay.
I don't think mom's going to prohibit that. But I know Mr. Chavez wanted scheduled time, so that's what he had, and there could be others.
Yeah,
okay.
If I'm open to more if he wants.
Okay, so obviously he doesn't have his own phone, so mom's got to make it happen. So Mr. Chavez, obviously you want your son to have a good relationship with his father, so you want to encourage some contact, but to make sure your son is safe. So if in fact your son expressed to you he wants to talk with his dad, the court's opinion, you should permit that.
Yeah, I'm not sure if there was a miscommunication in what Mr. Chavez was saying, but whenever Jeremiah asks, I always give him the phone to call his dad. So I definitely encourage it. Okay,
and that'll be over and above these FaceTimes, video contacts. All right, with that, we'll adopt the recommendation. Thank you, Mr. Kazmarek and Mr. Chavez. We'll see everyone back here then on April 3rd at 1:30.
Thank you.
Okay, you can all zoom out. Have a good rest of the day. Thank you, Mr. Walker. One moment, please.
Yes, Your Honor. This is Miguel Chavez, present.
Okay, just one moment, please.
Oh, okay.
Sonia Chavez versus Miguel Chavez.
For the record, this matter is before the court for a review of CPS and Taylor Police Department reports regarding an alleged incident involving defendant father and the minor child. This hearing this afternoon is being conducted via Zoom. Present is Attorney Jason Kazmarek, representing the representing the plaintiff mother, Sonia Chavez. Mrs. Chavez is present with Mr. Kazmarek. In addition, the defendant father, Miguel Chavez, is also present. Good afternoon, everyone.
Good afternoon.
Good afternoon, Judge.
The parties have confirmed with Ms. Maybell from the front of the court this afternoon, and the court proceeded to find recommendation. Pending the outcome of the investigation with the Taylor Police Department and our Wayne County Prosecutor's Office, defendant fellow shall have reasonable supervised parenting time with the minor child in the presence of the plaintiff or any agreed upon third party. Plaintiff's counsel shall be responsible for providing the status of the investigation by the next review dates. The parties agreed to reserve the issue of father's make-up parenting time in the event The outcome is that the defendant files not being charged with any criminal offense. The initial parenting time order to be practiced. And the matter shall be reviewed on May 22nd, 2024 at 10:30 a.m. Oh, I see. In the event the defendant is not charged, then I guess in the interim, that the parenting time previously ordered shall be practiced. The parties will appear back for the court to these matters on May 22nd, 10:30 a.m. That's the recommendation. The court would note, I don't know if Ms. Mayville received a copy of this. The Department of Health and Human Services issued a letter dated March 5, 2024, to whom may concern regarding the investigation of February 12, 2024 of physical injury to 12. The allegations are unsubstantiated. Currently, this is authored by Megan Anger, Child Protective Services. Currently, I have no concerns for Jeremiah's safety at the home of Mr. Chavez. This case is closed. No further concerns are present. Ms. Mayville, did your office have a copy of that letter?
Yes, Your Honor. Both parties agreed that the CPS investigation had been closed and was not substantiated, but there is an issue with the Taylor Police Department not receiving a denial or acceptance of a bench warrant. So the position is that their plaintiff is still fearful for the child's safety at this point.
That's correct, Judge. So I received an email. So I talked to the detective yesterday. The detective DiGiacomo sent me an email stating that he's requested a warrant from the Wayne County prosecutor for Mr. Chavez, which is still pending. It's not been seen by the prosecutor yet, so it's not been approved or denied. So he's awaiting that. The detective indicated in the email that he called him a few weeks ago but hasn't heard back. In fact, he just checked on it apparently very recently, and it still has not been reviewed. So it's still on the prosecutor's desk. I asked the detective how long that usually takes. He said anywhere between 2 weeks and 2 months. So we're waiting for the Wayne County prosecutor to act or not to act.
Mr. Krasmerk, does mom really want to prosecute dad, and she wants that child to testify against her father? I mean, really? I mean, we have a CPS report saying they have no concerns that the child's not in any danger.
I understand, but again, I think whether it's prosecution can involve anger management, things like that. I mean, this isn't the first time there's been allegations against Mr. Chavez. There's similar allegations of abuse back in, I think, 2022. I mean, if there is a prosecution, I don't know if she wants him to go to jail per se, but if that would involve, again, he's in counseling as well. If that would involve some domestic violence counseling, anger management counseling, things like that. Again, the disclosure was made not to my client at all. It was made to the school. The school called CPS, and then there was direction to call the Taylor Police to make this report. The child was forensically interviewed by detective. So those details have not been disclosed to my client or myself. But again, she doesn't know what he told the detective, but apparently whatever he told the detective was enough to have him request a warrant from the prosecutor. So there is concerns, and until she gets a copy of the police report, she doesn't know necessarily what Jeremiah said, frankly.
Well,
so yes.
What happened to the days when these things were dealt with within the family? Mr. Chavez perhaps wants you to engage in an anger management counseling program so that you can show mom that you've gone through some counseling and you're not going to respond in such a fashion as alleged. And then perhaps
absolutely
concerns. The old days, these things were dealt with in family. Why are we going to outside sources and dragging this matter out for months? What are we going to accomplish? So, Mr. Chavez, have you enrolled in any type of anger management or counseling program?
I can do that if that is required. I know I'm innocent of these charges. However, I would do anything in order to have the relationship that I've always maintained, stability, and that we've always had where we were dealing with it inside the family. Also, those prior charges were also unsubstantiated before. However, I will be open to anything because my son tells me he misses me.
You shouldn't have to be directed to do that. Doesn't it just make sense if your parenting time right now is suspended, or your son's making an allegation to the school counselor, not the mom, but school counselor? Don't you think you as a parent would take some action to alleviate concerns to make sure that
I will do so. I will do so, Your Honor.
Physically?
Oh, I would not ever do that. However, I would, yes, take whatever classes are recommended. Yes.
Well, it's been recommended taking like an anger management counseling program.
I will do so.
I mean, even if the Wayne County prosecutor charges you, that's really going to reflect what favorably upon you, the fact that you've addressed this thing on your own rather than being forced to do so. Be proactive, Mr. Chavez.
Yes, Your Honor, I will do so.
So it's recommended for the court today that your parenting time be supervised, and then we come back in another 6 weeks. What is your position on that?
If that's all I can get, then yeah, because I was told if there was any way to please Miss Anger, the CPS investigator, was asking me to please ask you if there can be if you can hear because she couldn't be subpoenaed because I didn't have a lawyer. But there's, of course, if there's any way you can reach out. However, I would also, yes, I agree. If the case is not closed, then yes, I do agree to, because to seeing Jeremiah supervised, I know I'm innocent, but we want to make sure that all parties know that.
Okay, have you had video contact with your son in the three
video contact? Yes, I have been getting. Some weeks I've been getting the 3, and sometimes I get more than that. I get at least 4 days a week. It sounds like. So she's been going a little above and beyond.
How are the sessions going with your son?
Very well. My son, of course, very well. I have many screenshots I took in of him kissing the phone, saying he misses me, saying he loves me.
Right. Mr. Kesmerk, does mom agree that the video contact between dad and the son have gone well?
I'll let her explain. She was actually what he was talking. She was explaining that. Go ahead.
For the most part, Jeremiah really enjoys his video contact with dad. There are times when he wants to hang up and dad doesn't want him to hang up right away. He has shown a little bit of just more or less frustration in those moments. Yeah.
So there's also been an in-person visit. I know that Mr. Chavez has come to some church events, seeing Jeremiah, as well as come to my client's home to see Jeremiah. Oh, I'm sorry, he was invited to do that. I don't know if Mr. Chavez showed up at the church events. He did come to plaintiff's home for about an hour. When was that?
Last Saturday.
Saturday
morning.
Yes. Last Saturday, yes. So again, I think my client's willing to work with him as far as whatever his work schedule provides. So that was discussion that Mr. Chavez could come to my client's home to visit the child unless they agreed on somebody else, which I think there's going to be some discussions about that. My client does not want to necessarily prevent Jeremiah from seeing his father. Jeremiah has expressed some frustration or anxiety about sleeping at dad's home to both mom and the counselor that he sees. I don't have that in writing, but that's been a concern of Jeremiah's. Don't know why that's a concern, but that's a concern that he's expressed. So that's where we stand.
Mr. Chavez, are you aware? Do you have the name of Jeremiah's counselor?
Yes, and I have reached out to her. I am expecting her phone call. I told her, I gave her my number and my email address. Once she be contacting me soon so that I can, because I like to do everything for my son's mental health. And of course, I always safety physically as well.
Okay. Perhaps you want to provide a counselor with a copy of this letter from CPS, but you want to make inquiry to the counselor of what you can do to make your son Jeremiah comfortable. And then my guess is you're going to say take an anger management counseling program. Maybe she can recommend an agency that does that. So I think the court's strongly encouraging you. I'm not ordering you. I'm strongly encouraging you to enroll in a anger management counseling program.
I will be looking forward today.
Okay, and then make sure you contact with the counselor and inquire with the counselor what you can do to alleviate any concerns that Jeremiah may have.
Amen. Yes, Your
Are you
Honor.
comfortable seeing Jeremiah over at mom's home?
I am comfortable. The only time that I went there, which was Saturday, it was very, very nice because he got to hug me, came and he hugged me multiple times, and we played as we always do. I'm a very interactive father. I would be willing to do that. Hopefully, that as long as me and him are able to have some time where we're safe. And I don't know how it is if somebody's always, staring at us. This kind of makes for something weird, or if it could just be something nice. But it was very, very nice, so I'm comfortable with it. As long as,
what about third party? You talked about a third party, maybe an aunt or a sibling that can supervise parenting time. It doesn't have to be mom, could be a third party that you agree upon. Have you talked about
I'm comfortable with mom or anybody that she agrees upon. Anyone, as long as my son can see me.
All right. Well, at this point in time, the court's going to adopt the recommendation, Mr. Kaczmarek and Mr. Chavez. Parenting time, dad's parenting time shall be supervised. Now, again, we're still going to continue the phone contacts, correct?
I would hope so.
Okay.
Video contacts. We can always do that.
So, do we need to? We'll continue just to make sure everyone understands the video contacts. Saturdays, Sundays, and Tuesdays shall continue as previously ordered. But in addition to the video contacts, there shall be personal contact, but it should be supervised in the presence of either mom or an agreed upon third party. Maybe you can take Jeremiah to a park on a Saturday or Sunday afternoon with the weather getting better, Mr. Chavez. And you can have mom, if mom wants to be there, she can sit in the car. You and Jeremiah can be out in the playground. Or you can, if mom's not available, find a third party that you're both agreeable with. And hopefully we'll have some information from the police department. The court would suggest to be proactive, Mr. Chavez, and complete an anger management counseling program. That will go a long way to make this thing go away. Okay, we'll review this matter then on May 22nd at 10:30 a.m. Any questions or anything further, Mr. Kaczmarek, from your standpoint?
Judge, thank you.
All right, Mr. Chavez, do you have any other questions, concerns?
As far as the visitations that I'm able to see him, is there a set? Is there like a limit? Because I heard that she'd be willing to work with whatever I have. Of course, the only days I have off are Saturday and Sunday, and
okay.
But does it matter when?
If she's not available, find a third party.
No, we suggested there's days he gets off around 5:30. So we suggested after work, any days that she's available, which is fine.
Well, what about a Saturday third party?
In mediation, we already discussed that. I said if there's a Saturday that I don't have a job and we're just at home relaxing, then you're more than welcome to come over.
But what about third party, family member of yours?
Yeah, we can look at that too. I have to speak with family and see who's able to do that for us.
Oh, jeez.
Maybe you have a family member, Mr. Chavez. Do you have a sibling?
All my family members live out of state, Your Honor.
Maybe you have a mutual friend, a former neighbor or something.
Oh, yeah, maybe somebody from church, a church friend, Sonia.
Sure.
If
we suggest that's fine.
We have anyone that the two we agree upon is acceptable.
Okay.
So come up with some names. If Ms. Chavez is not available on Saturday, Sunday, then propose another party and make sure that person's available to meet you at a park, or we'll see. You obviously have to be flexible with that third party schedule as well. So hopefully we'll have some closure on this and we get back to normal parenting time when we come back on May 22nd at 10:30. And again, the court suggests Ms. Chavez reach out to Jeremiah's counselor and also enroll in, perhaps even online, a anger management counseling program and provide documentation you've completed that.
Yes, Your Honor.
With that, the court will adopt Ms. Mayville's recommendation. Thank you, Ms. Mayville. Now we'll conclude this hearing. You can all zoom out. Have the rest of the day. We'll see you back on May 22nd, 10:30.
Thank you, Your Honor.
Thank you, Judge.
Your Honor. Thank you.
Thanks, Ms. Mayville.
I'm bringing in Mr.
Mr. Neal?
We're all here.
Court is now in session. Top of page 4, William Neal versus Jamie Ford.
Hold on, I got
Hello.
someone else. Who's on the phone?
William Neal. When I left the waiting room, it ended the meeting. I just hit leave waiting room and it ended the meeting. I'm reconnecting right now.
Okay, we can hear you, Mr. Neal. You're fine as long as we can communicate with you. For the record, this marriage before the court.
Hold on, he's got two.
Okay.
I'm gonna take him off to one. Can you still hear us, Mr. Neal? He hung up his phone. Can you unmute yourself? Mr. Neal, can you unmute yourself?
Yes, I'm unmuted.
There we go.
Okay, for the record, this matters before the court line defense motion to continue child support to pass the 18th birthday of the minor child. This hearing is being conducted via Zoom. President Attorney Maria Zagorski representing the moving party, Jamie Forker. Ms. Forker is present.
Yes.
And also the plaintiff father, William Neal, is present. Good afternoon, everyone.
Good
afternoon.
The parties have met with Ms. LaPrade. Mr. President, provided the court the following recommendation. Namely, that child support be reinstated and shall continue until and cease on May 31st, 2024. And that's recommendation, and that's what you're asking, your client's asking for, Mr. Gorski, is that correct?
It is, Your Honor.
The minor child will graduate in May of 2024, but will has recently attained the age of 18, but he's enrolled full-time in high school at this time, is that correct?
Yes, and Ms. LaPrade has a copy of the letter from the school that verified that the child will graduate on May 29th.
Thank you. Mr. Neal, do you understand the recommendation?
I do, Your Honor.
Do you have any objection to the court adopting the recommendation?
Yes, Your Honor, I do.
Okay.
The divorce decree that I have and states that the support ended at the age of 18 on the child's 18th birthday. Understandably, the law has changed. Miss Jordan had plenty of time to challenge these. She knew the law has changed. I never challenged the support. I've just paid my support. Now, if the court's ordering me to continue support, I'm good with it, but here's my but to this. I don't think it's right that I should be put into the rears for January when she failed to challenge in time to where it would just continue rolling through. I will pay the support from February on. I just don't think it's right. We were both sent 2 letters from the court challenging this. She neglected it.
No, I had the school fill the letter out when I received it.
Jamie, don't speak.
All right.
That's my position. If I'm deemed to pay the support, I'll pay it. But I don't feel it's right that I have to pay January and I'm automatically in the rears because the rears aren't my fault.
Correct. And of course, rears do not carry any interest at all. When did the child turn 18? In December?
December 26th.
Sorry.
December 26th, Your Honor.
December 26th. And Ms. LaPrade, when it happens, your office sent out a letter to the parties, is that correct?
Your Honor, typically what ends up happening is they get the emancipation letter when it comes back. We would, because there was no post majority, it would have stopped, and then the party has to file a motion because the order did not continue it. And I believe that's what happened here. The caseworker may have sent out a letter saying that the current support had stopped, but the system does not automatically generate that. No.
Okay.
Yeah, Your Honor, my client, I'm looking at a letter from Mr. Grumman informing my client that because of a child support order that was entered in 2015, child support ended as of December 16, 2023, and that letter is dated January 4th. My client contacted me. Of course, I filed this motion in January. We moved in a timely manner, and this child does have the right to be supported by her father.
Is this the youngest or the oldest of the 2 children?
The youngest.
Okay, so support right now is in the amount of what, 482 per month?
To tell you the truth, Your Honor, I don't know what was last ordered. It was 9 years ago, and my client never availed herself of a review and a possible increase. This amount was set in 2015.
Okay, I'm looking at the uniform support order of that was attached to the judgment of divorce in 2011. It was 42 for one child, 876 for two children. Mr. Pratt, what's the current amount of support?
$618, Your Honor, per month.
So there was an increase.
I believe Ms. Zagorski noted a 2015 order was the last child support order.
All right.
That was 9 years ago, and Mr. Neal has never had to pay more in those 9 years than that last order.
And the parties cannot reach an agreement about over this 1 month. Ms. Gorski, was that discussed at all in the breakout room between the parents?
No, I think it's policy and the law that the support just restarts. But I would defer to the court and Ms. LaPrade for policy.
Upon a motion, not automatically requires a motion, though, correct?
Yes, but that motion may be, according to the statute, which I cited in my motion, that motion can be filed anytime.
Your Honor, for the record, to answer your question, no, Mr. Neal did not ever request that he not have to pay January. He just told me that he did not agree to continuing the supports of graduation, just to answer your question.
All right. Can the two parents agree about some modification for that 1 month?
That's all I'm asking for. I'll go ahead and continue support until the graduation day. At that point, I would like it to be put on record that I am not obligated past that point.
The law says that, sir.
Well,
I have a hard time asking my client to make a concession when the law is clear. You know, Mr. Neal's position is that this child has a job, so he shouldn't have to pay, or that, you know, my client got the benefit of tax refunds, so he shouldn't have to pay. But that's not what the law says.
Okay. Mr. Neal, do you agree your son's enrolled full-time in school right now?
my daughter is enrolled in.
I'm sorry, your daughter.
Yeah, she is enrolled full-time in school. That is correct.
And with the expected graduation of May of 2024, correct?
I don't know any of that. Miss Jordan has kept the children away from me.
Right. Ms. Corsi, does Mr. Neal have a copy? You alluded to a letter attesting to the fact that this child is enrolled full-time with an expected graduation May 29th. Do you have a copy of that for Mr. Neal?
Your Honor, the friend of the court has that letter. Ms. Zagorski does not. It's a letter that's generated out of our system. It goes directly to the custodial parent, at which time the school fills it out and it's returned to us, signed by a principal or an administrator from the school. So I have that letter and it is dated that the child will graduate May 29th of 2024.
All right, thank you. This recommendation, Mr. Neal, does say that even though it recommends that the child support reinstated, but it says it shall cease May 31st, 2024.
Okay.
So it's pretty definitive. You know,
okay.
In other words, even if your daughter does not, if she decides to drop out and she's not going to finish this semester, then she's not going to be able to come back and ask for support beyond that date. Even if she does drop out, you can petition the court to stop the support if she's not going to school full time.
Understood.
So at this time, it appears to be appropriate that this support continue to graduation. So the court will adopt the recommendation. Child support will be reinstated. Yes, there will be. They're not going to show cause you, or you're not getting in trouble for having some arrears, Mr. Neal. There's no interest accruing on that. So just continue to pay your support.
That puts me in a financial bind.
Well, pay what you can, and I can't. I don't want you to deal with the front of the court attorney. So do your best. Do your best. And usually you get on the radar if there's a significant arrearage, but obviously it's expensive to raise children nowadays. This will be your last of your two children, correct?
Yep.
So At least, I don't know if the end is ever in sight. You're still going to help them out when they're adults, I'm sure, whether it's weddings or whatever, Mr. Neal. But in any event, again, this child support is reinstated. Will cease May 31st, 2024. The court will enter that order. That will conclude this hearing. Copies will be mailed to everyone.
So I'm automatically in arrears is what I'm being told here. I'm what? How much in arrears? So I can try to get that taken care of, sir.
Well, so I guess 1 month, $618.
Your Honor, there was already an arrears on the account, so I would suggest Mr. Neal reach out to Mr. Grumman after we get the child support reinstated.
Okay, so that's a good idea, Mr. Neal. Reach out to Mr. Grumman, let him know your situation, and because obviously, if he understands your financial circumstances, he'll work with you on this.
Your Honor, I've reached out to the front of the court multiple times, and they don't return my calls. But I appreciate your time. I will
you call Mr. Grumman, and if he doesn't return your call within 40 hours, you call directly to the court.
Thank you.
Your Honor, I would be happy to help Mr. Neal as well. He can call me.
Okay. Ms. LaPraz, the assistant director in front of the court, you can call Ms. LaPraz. She's offered that, Mr. Neal.
Yeah, appreciate it.
All right. All right. Good luck. That will conclude this matter. Thank you, Mr. Gorski. Ms. Jordan.
Thank you, Your Honor.
Thank you, Mr. Pratt.
Thank you, Your Honor.
Welcome.